For appellant, Mr. Stephen Torres. And for respondent, Ms. Annie Featherman Fraser. Case number S067392, the people, plaintiff and respondent versus Daniel Carl Frederickson, defendant and appellant. For appellant, Mr. Douglas Ward.
Ready?
And for respondent, Ms. Tammy F. Hennick. And case number S130263, in re Kenneth Earl Gay on habeas corpus. These cases continue to feature calendar.
Thank you. Calling the first matter, Don L. Mathews versus Javier Becerra.
Good afternoon, Your Honors. May the please the court, Mark Hardiman, Nelson Hardiman, on behalf of petitioners. While possessing and viewing child pornography is certainly a crime and is also particularly repugnant because it involves sexual depiction of children, petitioners, including licensed therapists who treat patients through psychotherapy for various sexual disorders, are asking this court to invalidate AB 1775, which amended the child abuse and neglect reporting statute to now require psychotherapists to report patients who have admitted to viewing child pornography during therapy.
Could I just ask you, counsel,
Please.
at the outset to clarify the scope of the coverage of the 2014 amendments? So there's some intimation in the record that the phrases downloads, streams, electronically accesses was meant as a technical update to the statute. Your complaint alleges that essentially this actually was an augmentation insofar as viewing and possessing would themselves be subject to reporting.
Correct. So at least based on the limited legislative history, there was no express indication that the legislature, which when it previously enacted CANO was pretty specific about the penal codes that they were referencing with respect to the definition of sexual abuse and sexual exploitation, and in many cases actually either referenced the penal code sections that were at issue in defining sexual exploitation or abuse, or at least use the same language. So the amendment didn't reference directly child pornography possession, which was notably absent from the original enactment.
But the reason for the amendment clearly was technology?
It appeared to be technology, but the words used, Your Honor, in
words used were?
The words used, download, access through electronic means.
And it didn't say simple possession.
It did not, but those words by themselves necessarily expand the ambit outside of the conduct that was previously reportable to under a reasonable viewing in the day of internet, accesses through electronic media necessarily, in petitioner's view, now includes viewing child pornography on the internet through a personal computer.
So it seems to me that there is a plausible argument that even the pre-2014 version of the statute could be interpreted to reach what you would call simple viewing or possession through the internet, insofar as it referred to duplicates and other sort of like verbal phrases that are technically what happens when somebody views something on the internet. But I want to understand the nature of your challenge. Are you challenging just the 2014 amendments, or are you challenging CANRA insofar as it reaches simple, what you're referring to as simple viewing and possession of child pornography, regardless of the precise source of that requirement?
The latter, Your Honor. So petitioners' view is that the language that was added to the statute, in essence, incorporates viewing or child pornography possession. While I understand Your Honor's point, and in fact, the Court of Appeals suggested similarly that child possession or viewing was somehow already incorporated into the pre-2014 CANRA, we respectfully disagree with that given how it is structured. You are correct that the C3 provision where the access through electronic means was added could plausibly be read, but to perhaps include it, but that is not the statutory scheme. The particular language in C3 prior to the amendment applied to a particular type of exploitation that was related to the distribution and exchange of images and did not include the language that was added.
But just to clarify, ultimately, your argument doesn't depend on necessarily accepting that view of the changes wrought by the 2014 amendments. At the end of the day, your argument is simply insofar as CANRA, as it currently exists, requires disclosure of statements about simple viewing or possession of child pornography, it is a violation of the state constitutional right to
Correct. And if
privacy.
this court concludes, which we would be happy if this court concluded that does not apply on its face through that language or otherwise to child pornography viewing, then the concern of petitioners with the court's pronouncement would end. But yes, to be crystal clear, regardless of how we get there in the interpretation, our view is that CANRA cannot be extended to include child pornography.
You don't understand there really to be any dispute about that between you and the Attorney General at this point, in terms of the coverage of the statute. I read their briefing to agree with you, actually, in terms of the coverage of the statute.
Correct. And the people's view is that the interpretation of this amendment it is clearly now requires reporting of child pornography viewing without more.
But doesn't downloading, streaming, and accessing from the internet of child pornography include copying and saving?
No, I do not believe as a technological matter, Your Honor, respectfully, that that's true. I mean, as a practical matter, it may, but viewing child pornography on the internet does not require that the actual file be downloaded to the PC, et cetera. There may
Is that
be
because you're envisioning somebody who just walks into a room and sees it on somebody else's screen? Just explain why that is.
Please. So, no, Your Honor, what it's envisioning is, as millions of Americans do, right or wrong, in terms of cruising the internet, looking for pornography or sexual images for personal reasons, that viewing is a behavior that is separate and distinct from duplicating, exchanging, sending to other people. To be clear, we are not challenging the reach of the statute with respect to conduct that flows over into what the statute defines as commercial or sexual exploitation. And I think that the legislature could reasonably conclude that if you're starting to print, duplicate, develop film, which was from an earlier age, obviously, that seems to suggest that the viewing is going further in terms of distribution of the material.
It seems sufficient to say that this phrase, accesses through any electronic or digital media, is pretty broad, so that if a patient were to say, I've seen images on my computer, that's enough.
That's enough.
Because that is an accessing through an electronic media.
It is.
So viewing, it would seem to me, would be covered by that.
It would. I mean, if you're and you add in an image depicting a minor,
right.
So you're in a scenario where a psychotherapy patient could be coming in, and maybe they do have pedophilia instincts that they're trying to control or manage, and have looked at child pornography, or maybe it's someone who has a compulsive problem with just viewing like a smorgasbord of pornography and is trying to control that, and along the way says, I was in the teen section and I believe some of those images, I don't know who they are, I don't know where they're from, but I believe that some of those images depicted children. Under the state's current interpretation, without any further information, we're going to violate the confidentiality of psychotherapy communications, and in petitioner's view, undermine the state's equally compelling interest in encouraging the very people that have deviant disorders or mental health issues, including in particular pedophilia or any type of sexual attraction, to go into therapy.
Could I ask you about that?
Could
I ask you about that?
Please.
So this argument about deterrence has been raised in other cases, Tarasov and others, in which we've grappled with the scope of this privilege and certain exceptions from it. we're at the complaint stage of this case.
We are.
We don't really have any record facts. We have your complaint, which has a number of allegations. I'm just wondering, so this question is leaping ahead a little bit, but I'm just wondering, this law has now been in effect for 4 or 5 years. Do we know anything about how this law has been implemented, how the psychotherapy community has reacted to it? Do we know anything at this
We don't know anything.
We don't know anything. So we just
We don't know either way.
we don't know either way. And so that's why you think this issue needs to be tried, in a sense, because there would be evidence developed on this very point.
Well, actually, maybe overly optimistically, we're hoping that actually you don't need evidence on the points raised by the people with respect to why including child pornography viewing is appropriate under pretty established precedent, to the extent that this court assumes and reaffirms that when it comes to issues of our mind and personality and our demons and disorders, reaffirms that really it's much more fundamental to our autonomy that our innermost thoughts and desires, however aberrant, not be revealed to the world than it is a diagnosis of some type of illness that just simply affects our bodily function. So what we're asking the court is to reaffirm the privacy and say that on its face, child pornography viewing by itself is simply completely speculative with respect to furthering the purpose of CANRA to protect the laudable and compelling purpose to protect children from sexual abuse, takes it in a completely new direction of prediction. And there is absolutely nothing but speculation and possibility, remembering that this circumstance only arises when therapists have already decided that the person who reports child pornography viewing does not represent a danger to children.
Could I ask you, counsel,
Please.
The Attorney General seems to argue that with respect to the privacy interest here, you are arguing you're arguing about the increment accomplished by the 2014 amendment.
Yes.
And the Attorney General says, well, that increment isn't really that big compared to what was already in the reporting law prior to 2014. So you don't challenge the prior law with
Nope.
respect to the balance of interests or even the reasonableness of the privacy interest there. I mean, in other words, for purposes of this litigation, we're sort of assuming, are we not, that the patients don't have a reasonable interest in privacy with respect to the reporting of all the prior verbs, duplicates, develops, prints, exchanges.
That is correct.
Such.
That is correct.
So to narrow the issue, you're suggesting that the viewing and the possession through these electronic coverage, in essence, tips the line.
Exactly. And Your Honor, there's always a bridge too far, right? I mean, someone could call it incremental.
Call it. They say it's incremental.
They call it incremental.
Already reasonable. There was already no reasonable expectation of privacy with respect to all this kind of behavior before, and now you're saying this one is just too far.
Yes, because we don't view it as incremental. Okay. We don't view it as incremental because we believe, petitioners believe, therapists believe, that the difference between someone who sexually abuses a child or sexually assaults a child or is involved in the industry of producing, duplicating, trading for deviant interest or, for that matter, for commercial reason is very different from now telling psychotherapists that they have to report anyone that may have viewed child pornography without any further information as to whether that patient presents a danger to children, because the psychotherapists are already required to report.
When you say very different, counsel, what is the most relevant difference of those two? Is it a difference in the scope of the statute? Is it a difference in the scope of the privacy interest? What's the difference?
Child pornography is ubiquitous. I think both sides agree that child pornography is taking over the internet. It's a real problem. But what that means, Your Honor, is that the breadth of people that are seeking treatment and the type of people that are seeking treatment without presenting any danger to children, or for that matter, providing any reasonable assistance to law enforcement to aid and rescue children, that we need to encourage those people to seek assistance from psychotherapy. And the state's interest in those people is very distinguishable from someone that is actively engaged in hands-on contact sexual abuse of a child, or for that matter is distributing child pornography across the world.
You don't challenge developed, duplicated, printed, or exchanged.
That's right. It's a separate penal code statute.
And if the amendment to that statute
Yes.
was for the purpose of the technology revolution and added the phrases downloading, streaming, and accessing child pornography because of the technology revolution, you don't see a relationship between the addition and the prior categories?
I do see a relationship, which is
Is it not close enough?
Well, no, because it's an inadvertent expansion of something that the CANRA, for good reason, did not include in reportable conduct prior to this amendment, which is child pornography possession. I respectfully disagree with the people's position that prior to this amendment, the CANRA required the reporting of child possession or viewing. If you look, Your Honor, at the statute itself, it references all these specific penal code statutes and doesn't say a word about the penal code statute 311.11 that criminalizes child pornography possession. That's missing, and the underlying provision, C3, is language from Penal Code Statute 311.3. So what they've in fact done under the auspices of CANRA is amended the language of a separate Penal Code statute that did not include the language that was added here.
When I look at the language, I'm following up a little bit on Justice Chin's question. When I look at the language download, it's defined as to copy from the internet. And I don't see how that's different from the word duplicates in CANRA now, that's been in CANRA for 30 years. When I look at the streaming part of the 2014 amendment, that's defined as to transmit or receive audio or video materials, and I'm not sure how that's different from exchanging. So I'd like to hear more why you think this is not just a technical expansion. I realize your argument is it criminalizes simple viewing, and the legislature hasn't gone that far to explicitly say that.
Right.
But this is knowingly download, as is knowingly develop or duplicate. Why is this technical update different in substance from what already exists in CANRA?
Well, I'm not making my point well, because my view, Your Honor, is that first of all, if it was the same, there'd be no reason to add the language, right? If the existing language could just cover electronic, et cetera, duplicates it, if it in fact is the same, there would have been no reason for the amendment. So you have to look at the language that they decided to amend the statute with. And yes, obviously, maybe they did intend for it to update to reflect the fact that most child pornography now, and most pornography in general, is not in print form. It's on the internet and available to everyone. That's what they meant to do. But our position is that they did not mean to include, notwithstanding the AG's defense that they did mean it, that they did not mean to now include mere child pornography viewing or possession. But the net impact, when you're a therapist that is now subject to potential criminal prosecution, who is facing a patient that may have admitted to that, but that the therapist thinks does not present any threat at all to children, I now have to violate the core confidentiality of the relationship. That is what the therapist is reading. If you're saying that, as far as you're concerned, this does not now incorporate child possession or viewing, this language, and really is merely updating the existing statutory scheme, we would be more than happy with that.
You'd be
Because
happy, you'd be
I
happy
think
with
there's
that.
an argument to be made that that's true. But
You're not advocating that position, but you would welcome that result if
Yes.
that's what we interpret the statute
Yes.
narrowly to mean.
yes.
I mean, I'm still stuck on this phrase. I think downloads and streams gets into some difficult technical issues about how the internet works, which I really have no idea about. But the terms accesses through any electronic media or digital media, I still am stuck on that. Viewing on a computer, regardless of how it came onto the computer, whether by internet or otherwise, is a form of accessing through electronic media.
Correct. There's no getting around. I mean, in my view, and obviously, I'm the petitioner here, I don't think there's any way of getting around the fact that access is through electronic means, just through, our general basic knowledge of computers includes viewing images on your computer, and includes viewing images on a computer without duplicating. I mean, it's so easy. You don't need to duplicate, you don't need to exchange, you don't need to develop, which is language from a prior time. So now, I think the therapists are reasonably concluding that when you say access through electronic means, it means what it says, which is if you look at a child porn image on a computer, you now have to be reported by your psychotherapist if you admit to that during the course of therapy.
Suppose the patient says, well, I've come to you for this little problem, and I do want to let you know, doctor, that I've been watching this stuff on my computer, and by the way, I have a file with 10,000 images of pretty horrific child pornography in it. Should that fall under either downloading, streaming, electronically accessing, or is it close enough to developing, duplicating, printing, saving, that it should be reportable?
I like tough questions.
I thought you would.
It's close. It's close.
That's why I asked it.
Your Honor, yes, it's close, because if you've got 10,000 images that you're cataloging, saving and putting into a file, arguably that is not that could inform the therapist's viewpoint that this is going outside of just viewing or simple possession, and that this person is probably distributing or engaged in exchanging with other people of the
But where do we
like.
draw the line? How much is enough?
Well, here's where we would propose that the line be drawn, Your Honor, is that in the world of psychotherapy, the therapists have an existing legal duty under threat of criminal prosecution in conformance with their professional standards of conduct to report any psychotherapy patient who they believe has either sexually abused a child or under the common law duty presents a serious danger to them. What we don't need...
You're talking about the dangerous patient exception.
Right. That already exists, Your Honor. So to the extent that the therapists, who I think this court should presume are a little better suited to evaluate the dangerousness of their patients, and the law seems to have assumed that should be, that line drawing should be for the therapist to do it. There's no reason to believe that the therapists as a class of people are not interested in protecting this state's children from sexual abuse. But it has to be based more than just viewing of images of unidentified children and under a provision that we argue is a little overbroad because it would appear to require the reporting of sexting between teenagers.
I know that you dispute what precisely the legislature's intent was in crafting the current version of the statute as it did. But imagine that the legislature makes a conscious, deliberate decision that it is worth the costs in terms of possibly deterring patients from
Yes.
seeking help, to stem the tide of abusive children
Yes.
by, for example, requiring disclosure of when somebody is acting not as a hands-on abuser, not as a hands-on exploiter, but somebody who is actively participating in the trade.
As a consumer, even as just...
The consumer, but as a sort of, as somebody who exchanges.
Oh, well,
right? Doesn't
no,
create
we're not
the-
disputing that.
Right.
We believe that's
What is the right framework for taking the legislature's interest in stemming the tide of child abuse into account? How do we weigh the sort of the incursion on the confidentiality of the patient-therapist relationship with the legislature's important goals?
Okay, so I mean, that's really the core of this, right? And I don't mean it as a matter of policy, but I mean it as where you have a laudable state policy. There's no dispute about that. We're trying to protect children. But you have an equally compelling state interest supported by a constitutional provision where psychotherapy is the poster child of the right to privacy for the very reasons this course has previously enunciated. So drying up the consumer market, much like the war on drugs, I do not believe under this court's precedent is enough when you're dealing with a fundamental right to privacy involving the disclosure of the innermost workings of the human mind, the drying up the consumer market, or the mere possibility, which is so attenuated, that an image might lead law enforcement, if they don't have the image already, because a lot of these images are ubiquitous, to rescue a child, or that all people that view child pornography shall just be categorically assigned to a category of danger. None of that reaches the level of justification that goes beyond pure speculation and ambiguous.
You say that, but and there's some plausibility to it, but don't we need some facts in order to make these determinations?
Facts with respect. Okay, so if we went back down, we could have a debate about whether child pornography viewers represent a danger. Levels of danger. What other facts are necessary? But what you've got, the reason I don't think we need those facts is that CANRA, protecting children, has never involved prediction of future behavior.
But counsel, let me pick up on that, and
Yes,
it'll take
please.
us back a little bit, I think, to the question that Justice Kruger was trying to get you to focus on. So I understand that you question how wise a policy it would be to focus on viewers of child pornography. I completely understand that. That may even have a bearing in how we think about the constitutional right to privacy and how we weigh it relative to the compelling
Right.
state interest. But you keep referring back to CANRA and what its goals are, and I want to isolate how much of your argument really is about that, and how much of it really isn't about that, how much of it is really about just the core privacy right here, if they're, to the extent that you define it the way you do. And to try to get at that, I want to ask you, suppose the legislature had done the fact-finding, had decided that your argument is plausible, other arguments are plausible, they're going to have a ton of hearings, lots of experts, debate and discuss this, and then they're going to enact a law that is a lot like CANRA, except it's more unambiguously reflecting the conclusion that from the legislature's perspective, mass viewing of child pornography drives this problem. It actually incentivizes the exploitation of children. It's dangerous, it's terrible, and the legislature wants to clamp down on that.
Mm-hmm.
And so there you have it. If that's what the legislature had chosen to do, how much of your argument would really be different?
We're still here.
That's what I figured.
We're still here because that type of broad brush, categorical, like predictive analysis of future behavior based on past behavior is precisely the type of justification by the legislature that this court has traditionally, at least when constitutional rights are involved, hit the pause button, because it cannot be at the expense of the equally compelling interest to encourage patients to seek therapy. I mean, we want to have patients seeking therapy to avoid them acting out on their impulses by having the core confidentiality of the efficacy of psychotherapy suddenly undermined by a legislature saying all child pornography viewing contributes to the consumption of child pornography, and therefore everyone that goes in to seek treatment for that does not have a right to privacy anymore. It has to give way to this sort of categorical approach to a class of people.
Mr. Hardiman, your time has expired.
It is.
The way you've structured it, and you've gone way over. But
way over.
I know you've had a lot of questions, so two things. It doesn't cut into Mr. Norris's 10 minutes, but you only have 3 minutes on rebuttal.
I
A firm
appreciate
3.
That's very fair. Thank you.
Good afternoon. Thank you, Your Honor, and may it please the Court, I'm Trent Norris, representing the 14 scholar amici. We very much appreciate the Court's permitting us to speak today. And as the Court can see, there's a substantial academic community that has studied these issues, analyzed them, and researched them over many, many years, and in great depth. And given the legislature's failure to consult any of that literature or these individuals who study it, we appreciate the Court's willingness to do so. Now, our amicus brief focused on really the balancing test of Hill versus NCAA and the literature that has been developed in the social sciences around pedophilia, around treatment, et cetera. The Court has denied our motion for judicial notice on those matters, presumably because these are appropriate for the trial court to consider. This case, of course, arose on demur, and none of that information has been presented to the trial court. There's been no opportunity to do so. So I want to focus today on the one issue that Hill versus NAACP says is an issue of law, and that is there a privacy right here that is implicated? It's hard to say otherwise, in our view. And indeed, we think that there is an autonomy right, the autonomy version of a privacy right, not merely informational.
And counsel, could you be more specific about the four corners of that privacy right as you understand it? Is it in viewing the pornography? Is it in the communication to the psychotherapist? Is it in something else?
It's in the communication with the psychotherapist, and indeed it's the entire aspect of psychotherapy under which if there is any more private sort of activity than seeking assistance in controlling one's own urges, it's hard to imagine what that would be. And where the court has limited autonomy privacy, this court and the U.S. Supreme Court, to issues affecting abortion and child rearing and family planning, we think that that is ripe for expansion, indeed, to cover something that involves not merely controlling the body, but controlling the mind. From the dawn of psychotherapy in the modern era, there's been discussion in the Freudian world of the superego attempting to suppress the urges of the ego or the id, and this is the entire role by which people seek psychotherapy in these matters, which is to pursue their own autonomy, to be their own person, to not suffer the consequences that they might suffer if they're unable to indeed do that. And we think those true up very nicely with the American Academy of Pediatrics and its discussion of a woman's right to an abortion and to avoid parental consent. There's an informational aspect to this, of course. There always is, because information has to be transmitted in that. But this, we think, is fundamentally at the heart of the right of privacy. And I'd refer the court to the ballot pamphlet. Justice Mosk summarized it in his dissenting opinion in Hill versus NCAA, and made it very clear that at the heart of this was the ability, the associational ability, the expressive ability of individuals to undertake these types of examinations, freedom of thought, essentially, which we think is a part of all of this. And so we would urge the court to consider that.
Is it the consensus of your 13 clients that there is no relationship between downloading, streaming, and viewing child pornography and acting on those impulses?
Indeed, Your Honor. And in fact, if anything, there may be an inverse relationship. It is a very different population. And the studies that have been done on the populations of those who are mere viewers of child pornography, not to minimize the harm that that might inflict, but the
I
mere
don't want to
viewers.
make decisions based upon newspaper articles, but there are two recent ones in the New York Times.
Yes.
Are you familiar with them?
Yes, absolutely.
Those seem to be contrary.
Well, obviously, if someone's engaged in the distribution or the production of child pornography, they're a viewer as well. This is a very small subset, and the studies that have been done on those who've been convicted of viewing child pornography find that, number one, they have very little criminal record, even compared to all others in the criminal justice system. They lack the antisocial traits. They are doing this in the privacy of their own home. And that it's a very different subset. They are not the likely ones to actually harm the child. And so, on top of that,
The people that were interviewed for these articles were already incarcerated.
yes, oh yes, well that's true. That's a subset that will subject itself to further study. Those that are not are unreachable for obvious reasons.
Issues that could be profitably explored through factual development in the trial court?
I think they could, Your Honor. And indeed, it goes to a variety of things. The reasonable expectation of privacy prong of NCAA versus Hill. You have a situation today where for 50 years, it has been perfectly legal to view pornography, adult pornography, in the privacy of one's own home. That's very well known popularly. It's also very well known in part of our culture that psychotherapy is confidential. The one thing on which there may be some confusion is whether accessing an image electronically such that electrons are sent and assembled on your phone is duplicating or maybe copying in some manner. That might occur there. So when the Attorney General says, this was already covered, or it may have already been covered, and there couldn't be a reasonable expectation of privacy, well, it's a heads I win, tails you lose. You know, there's a circularity of the reasonable expectation of privacy. Clearly, there's a legal background that's part of it, but the legislature can't change the reasonable expectation of privacy with a statute, with the statute that we are challenging at this moment. That can't possibly be the way that this gets analyzed. And I think, in general, do people have a reasonable expectation of privacy in viewing these? Yes, we contend that they do.
Can you expand on that? Because I know that the second prong of the Hill is reasonable expectation of privacy in the circumstances. And I think you just mentioned in the circumstances is we've had decades of CANRA. So if we were to find or agree that accessing is duplicating and downloading is duplicating, accessing and by any electronic means is a technical advancement, then how can there be a reasonable expectation of privacy in the circumstances?
Well, because number one, Your Honor, I don't think that the average person understands necessarily that that is a duplication that's occurred. But number two, the verbs used before, duplication, printing, and exchanging, all show an intent to circulate, an intent to distribute the pornography, as opposed to accessing. You could be looking at it over someone's shoulder on their own device. That's accessing.
But as Justice Corrigan had asked, it's also about creating your own personal library, isn't it also?
Well, if that were the case, there might be some aspect to it, and the legislature could draw those lines differently. Here, they've wrapped in an entire spectrum of behavior where there's not any harm that can be prevented by the psychotherapist reporting. All that can happen is that the individual then faces a myriad of law enforcement consequences. And the Attorney General says, there's safeguards from the privacy of the report. Well, that may be true, but there'll be a knock at the door, sure as anything, and a further prosecution of this individual that's been reported, and that will be public. That in itself is no safeguard.
Could I ask if any of the scholarship that either your clients have done or that you're familiar with address the law enforcement side of the equation?
Meaning
how are these laws applied? How do they actually get used?
Well,
what kind of prosecutions are brought?
Well, quite interestingly, so in the recent Regents case, which the Attorney General brought to the court's attention, there's a quote which we think is quite unfortunate that says that there is no empirical data on these issues. But the cited reference, which, by the way, is a law review article and has no empirical studies as part of it, makes very clear that empirical data to address definitively many of these questions and fears must await further studies due to the fact that the base rate of violence by psychiatric patients is so low. Now, that was written in the Tarasoff context, I would say. In this context, That rate is also vanishingly low, as many of the studies we submitted show through the Department of Corrections, the Department of Justice review, et cetera. So the number of offenders is a very, very small number there. And yet what you have is a chilling effect that this statute, which has been on the books now for several years because of the delays in this case, that it effectuates on the desire of those who want to change their behavior through the assistance of psychotherapy to actually seek that out in a candid forum where they have this autonomy, privacy interest to actually address it. And so we think it's counterproductive and would fail even the balancing test, but certainly we think that the state needs a compelling interest, which they've not shown at all. Thank you, and with that, I'll yield my time.
Thank you, Mr. Norris.
May it please the court. We think AB 1775 is properly understood as a clarification of the longstanding duty to report when a mandated reporter has a reasonable suspicion that someone has duplicated, developed, printed, or exchanged images of a child's sexual exploitation. But even if AB 1775 is understood as an extension of those requirements, it is still constitutional because the state's interest in addressing that kind of conduct is sufficient.
Is it your position that mere viewing is enough?
It could be if it gave rise to a reasonable suspicion that the person had engaged in the covered conduct of downloading, accessing, or streaming. So if a person...
Where do we draw the line?
I think it would depend on the particular facts of the case, but if a patient informed a therapist, for example, that he had images on his computer of children's sexual exploitation, that would very likely give rise to a reasonable suspicion that the person had downloaded, accessed, or streamed those images.
But that's not a determination, counsel, that the legislature could make in its wisdom?
It absolutely is a determination the legislature could make because the state has critical interests in protecting children from sexual exploitation well beyond the interest that my friends on the other side have articulated in terms of preventing children from hands-on or contact abuse. The legislature, the state, has a critical interest in addressing the harm that is inflicted through the downloading or accessing in itself, which is widely recognized in this court's cases and in the U.S. Supreme Court as inflicting grave harm by invading the child's...
There's no question that's harmful, and I don't think anybody would dispute that. I just want to clarify or hear once again what you had just said about the coverage of the statute. So if a patient says, I've been viewing these images, child pornography images, on my computer, full stop, that is enough.
Very likely, yes. That would give rise to a reasonable suspicion of downloading.
How could, you still say that kind of cautiously, how could that not be an accessing through an electronic media?
I think it would, Your Honor. I think that there would be closer cases in situations where somebody said, I walked by somebody else's computer and my eyes passed over a disturbing image. But in situations where the person is controlling the computer, then yes, I think it would give rise to a reasonable suspicion. And the state has interest sufficient to justify reporting in that context.
So would the same interest justify a requirement by the psychotherapist to disclose any time a patient reports having committed any kind of crime? I mean, so the entire penal code is designed to protect public safety, right? It serves an incredibly compelling interest in our society in protecting society in general. The argument that you have just made for the compelling interest that underlies this particular disclosure requirement, it seems to me would apply to a much broader range of disclosure requirements having to do with any form of public offense.
I think it would be a much harder case in situations involving any kind of criminal conduct, and the state would bear the burden of showing that it had sufficiently strong interests. And with regard to general criminal conduct, the state very well may have weaker interests than the ones that are present here.
What is the difference? So, to take the example that's given in the briefs, a requirement to report whenever your patient has used illegal drugs, for example. What is the difference between that scenario and this one?
The scenario here involves victims who are generally unable to report themselves. They're unable to extricate themselves from abusive situations. The victims are especially vulnerable, and the abuse often will occur in private or family settings. And those characteristics of children are precisely what underlay the legislature's decision to adopt mandated reporting laws like CANRA, because abuse was dramatically underreported, and the legislature concluded that it was reporting and not silence that would protect children.
If I may, the interest that you're articulating is a slightly different interest than the one that you mentioned a moment ago. The interest in actually preventing the children who are the subjects of the child pornography from being abused and being exploited is a different interest than a sort of pure interest in enforcement of the criminal laws. And it seems to me just how close the disclosure requirement is in terms of its relationship to that interest probably requires us to know something about how often disclosing actually assists law enforcement in preventing the abuse and identifying children who've been abused and stopping those practices, doesn't it?
I don't think so. I think that the connection between the state's interest in protecting children and the reporting requirement is sufficiently clear from the face of the statute. The statute contemplates reporting of a limited set of facts, and it gives law enforcement and child protective agencies tools to use that information to protect children. So it allows them to investigate the circumstances of the downloading and identify situations in which the downloading has been done by someone who has access to children in his job or otherwise. There are statutory tools that allow law enforcement to obtain search warrants and confiscate the material to prevent the further re-victimization of the child who's depicted in the images. And there are statutory tools for, in appropriate cases, the district attorney to prosecute.
So if studies showed that despite the availability of all of those very important tools, as a practical matter, the nature of this market is such that they have a 1 in 100,000 chance of being effective, of stopping abuse. This is just a hypothetical. I have no idea what the true answer is. But if that's what the studies showed, would that be entirely irrelevant to the inquiry?
I think that the state does not have to marshal empirical evidence. I think it is sufficient here that there are tools to enable the law enforcement community or child protective agencies to address even just the circumstance of the downloading. And so when an instance of downloading is brought to the authorities' attention, they can address that, they can investigate it, determine if the person has access to children, they can go and confiscate the material. And so the connection is clear from the face of the statute. The ways in which the reporting requirement advances the state's interest in protecting children.
Would it matter to you if, I know you may dispute the factual statement I'm about to suggest, but would it matter to you if evidence actually showed that the statute, though having sometimes the salutary effects that you suggest, more often has the effect of deterring people who would seek treatment from actually seeking treatment, and thus they continue in their illicit and antisocial behavior, thereby compounding the very problem that the legislature sought to address? Would that matter to you if there were would that matter to this analysis if evidence showed that?
I don't think so, because under the Hill balancing test, the state has to show that it advances its interests in some respects. And so even if there were a subset of patients who were deterred from obtaining therapy, the plaintiffs here are seeking invalidation in respect to all patients, and that the scenarios of deterrence that have been described wouldn't apply across the entire patient population who's at issue here.
So even if it were, I'm just puzzling at the limits of this reasoning, even if 1,000 are deterred for every one that turns up a helpful tip, that's okay? Doesn't that sort of short shrift the right at stake here? That would seem to be a very attenuated relationship between the means chosen by the legislature to advance the stated purpose, and yet there's a very high cost exacted on the right. At least some cost. I mean, we could disagree about how significant the privacy interests here, but psychotherapy involves some privacy interests. I think you would agree with that, at least.
Psychotherapy communications in general, of course, there are legitimate privacy interests in psychotherapy communications in general. The question here is about the nature or strength of the privacy interest with respect to reporting of a discrete set of facts that are relevant to an incident of child abuse. So we don't think there's a reasonable expectation of privacy in that particular
why not? So somebody comes into a therapist's office, they have a pre-existing relationship with that therapist. They say to the therapist, I viewed child pornography on my computer. It's wrong, it's abhorrent, I'm upset about it, I am here so that you can help me stop this very dangerous and problematic behavior. No privacy interest there?
There is not a reasonable expectation of privacy in the disclosure of the fact that the patient has engaged in downloading child pornography. There isn't.
Why not? Simply because it's a crime, full stop, or there's something unique going on here?
No, it's not simply because there's a crime. It's because of the question of reasonable expectation of privacy turns on whether there's an objective entitlement based on customs, the legal backdrop, and the existence of notice is also relevant. All of those factors point against a reason.
Do we know on Demur the answers to some of those questions? So, for example, do we know on this record whether prior to the 2014 Canra Amendment, therapists thought it incumbent upon them if somebody walked into their office and said, I have viewed child pornography on my computer? Do we know if there was an expectation in the therapist community that they would have to report that under the original Canra formulation?
The legislative history reflects that the psychotherapy community was confused about the existing duty to report in the case of child pornography. And the two organizations of psychotherapists asked the legislature to enact AB 1775 to make clear how their reporting duties applied in the internet age.
But isn't that similar? Isn't that tantamount to saying that for many decades, that is, since the invention of the internet up to 2014, a patient seeking therapy may well have had a reasonable expectation that they could walk into a therapist's office and admit that they'd viewed child pornography on the internet, and there would be no reporting requirement?
No, I don't think so, because the verbs that were in the prior version of CANRA all spoke to conduct that involved a therapy patient consuming child pornography. And the addition of downloading, accessing, or streaming made clear that those verbs applied in the context of the internet. And my friends on the other side have suggested that the verbs in the pre-AB 1775 version of CANRA applied only in situations in which there was a commercial exchange. That is not correct. In the case law interpreting section 3113.3, which uses the same verbs that were in the pre-2014 version of CANRA, have interpreted duplicate to apply to situations involving non-commercial exchange, and indeed the exchange of a very small number of images, even across electronic media held by the same person.
Let me take you back for just a moment to Justice Groban's hypothetical. In Hill, as you know, there was a distinction drawn between whether there's legal cognizable privacy interest and whether there's a reasonable expectation of privacy. And in answer to Justice Groban's question about whether there was a privacy interest, you said, no, there's no reasonable expectation of privacy. So I want to just press you a little and ask whether that means you recognize at least a legally cognizable privacy interest, but you're just disputing whether there's a reasonable expectation of it.
We don't think there's a legally cognizable interest in communications in therapy that a person has downloaded or accessed or streamed child pornography, and that is because of the legal backdrop that has existed for many years that has required reporting in cases where an individual is consuming child pornography, and has also had an exception from the psychotherapist-patient privilege for conduct that is reported pursuant or information.
Let me pursue that if I could. Is there a legally cognizable privacy interest in any communication with a psychotherapist that involves the violation of a criminal law? In your mind?
There certainly could be. The question would turn on the specific facts and legal backdrop of the particular case. We know in the case of child abuse reporting that there's a particular legal framework and a particular set of social norms that are in favor of disclosure, even if the information concerning the abuse is communicated in what would otherwise be a private setting. And so we don't think that the plaintiffs here could make out a cognizable privacy claim here, but even if they can, the state's interests are overwhelmingly weighted in favor of permitting this law.
Are you aware of, excuse me, please.
Thank you. In 25 words or less, how would you characterize the state's interest that overrides what otherwise your friend on the other side argues is a pretty long-standing recognition of privacy?
The state's interest is in protecting children from sexual exploitation, including the grave harm that is inflicted on them when someone downloads images of their sexual abuse.
Doesn't that go back to Justice Liu's question about scope? And my question, as a follow-up, how do we know that this particular imposition of a requirement serves the interest that you have articulated? We're just supposed to intuit that?
We think that the statutory framework is sufficiently clear to demonstrate the requisite level of connection between the means chosen and the interests being served. And CANRA requires mandated reports. It requires then cross-reporting across various child protective agencies and requires investigations. Those statutory tools allow child protective agencies to determine instances in which individuals downloading child pornography may have access to children. It allows them to confiscate that material and prevent re-victimization.
You've said a number of times that this is clear from the face of the statute, but statutes are written oftentimes to achieve one thing, and then they have a whole bunch of unintended consequences. I guess I'll just offer you my maximalist hypothetical, which is, what if the effect of this law is to deter everyone who would otherwise seek help from seeking help? And thus, the purpose that the state says is served is actually a null set, because there is nobody now who would go to a psychotherapist and say, I've been watching child pornography on my computer. Would that evidence matter?
I think it would be...
But I'm just saying, don't we have to have a trial or some discovery to know whether it's that scenario or some other scenario that really is going on out there?
I don't think so. I think when there is a connection that is evident in the statute, that this kind of question is amenable to resolution as a matter of law on demurrer. And the question under Hill is whether the statutory structure is reasonably calculated to further the state's interest. And the weighing of these issues with regard to what deterrent effect, if any, would exist versus the public safety benefits from reporting is really one for the legislature to decide.
Did the legislature find any facts regarding these kinds of questions?
the legislative history shows the legislature's concern with the proliferation of digital child pornography on the internet, and the concern that the tools in CANRA before were inadequate to address that. There is a very long history of the legislature's attention to mandated reporting, including the original overhaul in 1980, where there was extensive testimony about how underreporting presented a grave risk, that it left many circumstances of child abuse unreported, and that reporting was the way to address that concern. This court in BH said that it is reporting that is often the only way that instances of child abuse can be brought to the attention of authorities. So we think in this situation where there is a long-standing legislative recognition that reporting protects children, this court's recognition that it's important, it's oftentimes the only way that it's brought to the attention of authorities, coupled with the clear connection that I've explained, that is sufficient as a matter of law here.
But what role do you leave? There must be some role for us, even if it's not compelling interest, even if we're just doing the Hill kind of balancing test. On one end, you have your friends on the other side saying, if someone comes into a therapist's office for treatment, wants to stop viewing child porn, and before they begin to speak, the therapist gives them a Miranda warning of sorts that says, you should know that if you report in any way having viewed or downloaded child pornography to me, I will immediately report you to the authorities, from which all sorts of quite serious criminal consequences may flow. I think you'd concede that on that side of the balancing test, such a required Miranda warning would not be beneficial to the therapeutic relationship. On the other side of the balance, you say that reporting will effectuate the ability to stop the dissemination of this pornography or aid the victim. Your friends on the other side on demur say, not true. There's millions of images. The person can be thousands of miles away. It's not going to happen. And we're on demur. What role do we have in balancing that, and why shouldn't we just say we need more factual development in that balance?
We don't think it's necessary in this case, and that the question can be decided as a matter of law in light of the long-standing recognition that reporting serves the interests of protecting children, and the connection. The statute provides on its face the tools that show how the state protects children when it receives information through a mandated report. I think it's also important in assessing the balancing here to understand the limited nature of the report that's at issue here. It is only facts that are relevant to the abuse. It doesn't include information about the communication between the therapist and the patient in general, or the diagnosis, or the patient's feelings. The report is confidential, and there are prohibitions against redisclosure. So the question at the Hill balancing test is, does the state have interest sufficient to justify that asserted intrusion? And so the very limited nature of the privacy intrusion, coupled with the clear connection between the reporting requirement and the state's interest in protecting privacy, together allow the court to decide as a matter of law that plaintiffs cannot prevail in this claim.
I'm wondering whether your argument is a little at odds with itself. On the one hand, you're characterizing this intrusion as minimal, and on the other hand, you are arguing that the law is required to assist in enforcement and protection. So doesn't that imply that if the report is made that somebody from some agency is going to be knocking on the patient's door saying, by the way, we'd like to look at your computer, and making all other kinds of inquiries, which doesn't necessarily strike me as a minimal intrusion?
It's a minimal intrusion into the patient-therapist relationship. And that is the privacy right that's being asserted here, is the confidentiality or privacy in the psychotherapist-patient relationship. And the actions that the child protective agencies might take in light of the limited information they receive about the therapy session don't further intrude into that psychotherapist-patient relationship.
Except that my therapist has ratted me out.
The plaintiffs here have alleged, and my understanding is that therapist ethics codes require them to inform patients about the limits of confidentiality. This is something that has been part of California law. This type of exception has been part of California law and recognized by this court for decades. In Tarasaw, for example, the court held not that therapists have duties to warn, and in circumstances in which a patient is dangerous, and that is very much of a piece with what we are talking about here.
Could I ask you, in the entire period before this 2014 amendment, are you aware of any prosecution of a psychotherapist for failure to report viewing?
I'm not aware of one, but it doesn't mean there necessarily hasn't been.
Are you aware of any evidence that would suggest that that psychotherapists were under such a duty?
The therapist.
Words that the Department of Justice or other law enforcement entities did regularly or even sometimes receive reports of that nature.
So I don't have information about that. The reports are made to local agencies, and the information that the Justice Department has is that I am aware of is more in the aggregate, and so hasn't been analyzed at that sort of granular level of detail that I'm aware of. But I don't think that the Hill balancing test imposes a burden on the state to marshal that kind of empirical evidence to justify the statute here.
So can I understand your argument in support of the constitutionality of the 2014 amendment, as I understood you to start, is it was merely a clarification. So I take it to believe that the words downloading, access, and streaming are and can be interpreted to be the way that people access child porn in the year 2014, because frankly, I don't know where you can buy the stuff. And unless you're a manufacturer and you're cutting and pasting and developing negatives in your back room, you're also not developing and printing. I think I understand that argument. And then you turn and you've spent a lot of time on the Hill balancing test, but yet at the same time, you've really turned to the affirmative defense of the state's interest. But that also doesn't mean you still advocate, however, that there is still no legally protected privacy interest. And in the context of the 30 years that CANRA's been with us and what it has already required therapists to report, that in the context of a patient coming in to talk about accessing and downloading, frankly, it's in the context, it's not reasonable to assume that they believe that they had a privacy interest in this.
That's correct. It has been the norm and the law in California for decades that psychotherapists must report conduct involving the consumption of child pornography, and that the psychotherapist-patient privilege does not apply to that information.
It's also my understanding that when you argue to us about the state's interest, you're asking us to look at the statutory scheme of the reporting and showing that the state really has paid attention to this and is looking to enforce it, if necessary, in its local communities. But also, you're telling us we can glean from the legislative history of CANRA 30 years ago that this was about protecting children that cannot protect themselves.
That's absolutely right. The legislative judgment from that time, continued to this day, is that it is reporting and not silence in these circumstances that protects children. And that has been recognized as the premise of California reporting law for decades. And I don't take plaintiffs to challenge that in general. they have conceded, as this court has noted prior to when my friends were here at the podium, that the other side has not challenged the constitutional balance as it applied before AB 1775 was enacted. We don't think there is anything in modernizing CANRA to apply to the new threat of internet child pornography that would suggest there would be any difference in regard to the constitutional balance that would be struck here. If the court has no further questions, we will submit. Thank you.
Thank you, Ms. Feinberg.
Your Honors, in my 3 minutes, there is one thing we would agree on, which is we don't think we need fact-finding under this scenario. The mere fact that there is a laudable purpose, which we all agree about, the statement of that purpose does not inherently validate the actual enactments by the legislature and insulate them from constitutional scrutiny. If this court, Your Honor, decides to look at CANRA and say this already required possession or viewing of child pornography dating back to when it was just in print to be reported, then the petitioners just got it wrong, that it was already there. I would encourage you to look at the structure of the statute and the definition pre-2014 amendment, because I don't think it's a supportable interpretation. The way it's structured is by reference to penal code sections that define sexual exploitation, that define commercial exploitation, that define sexual assault. And it is not, you cannot presume that the legislature simply omitted the child possession statute under elementary sort of statutory construction. If they omit a particular law, there's usually a reason for it. In our view, the reason is simply this. Reporting child pornography viewing does not further the purpose of the CANRA statute, which as a whole, and I encourage you to look at the entire statutory scheme, has no provision other than this one for the reporting of predictive behavior in the future of child abuse or child neglect. It's actual incidents of live children being abused. Now, my friend, and I think it's a powerful and appealing argument, but it's wrong, says, well, the viewing of the image is all the abuse that needs here. But that is by itself. None of the rest of the statute has ever indicated that the act of viewing a child pornography image is the type of abuse that CANRA was designed to protect. This statute is not a law enforcement statute, Your Honor. It's not geared to what law enforcement wants to do with it. It's geared to protecting children. And so what you're left with, Your Honors, and I'll conclude, is that there is really no basis. You can adopt this notion that looking at the picture is abuse, but even the Supreme Court recently, when it was dealing with the issue of damages to the victim, and I don't necessarily agree with this characterization, but said that the viewing, to the extent that it's abuse, is very minor compared to producers, the manufacturers, the actual direct victimizers of it, and the likelihood that an image that was viewed by a patient is going to lead to the identification or rescue of someone. I mean, it's madly and transparently speculative that the law enforcement doesn't already have it, that the image will provide any type of ability to identify. And I'll leave where I began, Your Honors, which is it's unnecessary. If a patient comes in and says, I saw an image of Amy down the street in a child porn image, that's reportable. If a patient comes into a psychotherapist
Is that
and says,
reportable?
That's reportable currently without this amendment, because it's an identifiable victim of actual abuse that is actually reportable.
What about your friend's argument that certainly having this information would at the very least allow Child Protective Services or somebody to inquire whether or not this person has ready access to children? Whether they're a preschool teacher, for example, or a Boy Scout leader, or name any number of people who have ready access to children.
And do what with it?
To protect the children?
Well, to prosecute the viewer, but that's a good question. My answer is simply that assumes, right? That assumes that child pornography viewing as a predictive matter, which Canada has never addressed before, ever addressed before, like here's an act that we can predict that this particular person may be a danger to children, which is what you're positing. That's never been within the statutory scheme of Canada. It's dealing with scarce law enforcement resources to report actual abuse so that it can go in and be protective. I'm not quarreling with the notion that perhaps you could have a prophylactic system that requires psychotherapists to report all kinds of antisocial conduct that might lead to a possibility. But this court's precedents put a complete break on that and said you actually have to have imminent threat of an identifiable victim. And with that, I'll close. Thank you for your attention, Yours.
Thank you, Mr. Hardiman, Mr. Norris, Ms. Feinberg. The matter submitted.